Now we are moving to the next classification or next group of fundamental rights, that is the seventh group of fundamental rights is right to freedom of religion. 4 articles are discussed in the freedom of religion in the chapter of fundamental rights or in the part 3, the fundamental rights of the Constitution. Articles starting from 25, 26, 27 and 28. These 4 articles discusses about the freedom of religion in India. India, as we discussed earlier in the preamble of the Constitution, is a secular country and there is no official religion for the state, and each and every religion should get an equidistance from the state, or the government, the state should have a equidistance policy towards each and every religion. Then let us check the articles one by one. What is Article 25, 26, 27 and 28? Article 25, that is one of the most important articles in the Indian Constitution. 25 discusses that there is a freedom for every individual to preach, practice and propagate any religion. Then all individuals in India, and simply you note it down that this is an individual freedom, not the freedom for a group of religions. Then this is each and every individual in India has the freedom or the right to preach, and you have the right to preach, or preach means that spread to other people in a peaceful manner without violating their consciousness. Everybody has a consciousness. All the individual has their own self and self-determination, self-decision. Then preaching means that whatever you believe, if somebody is believing in a particular religion, they can communicate with the other people in a dialogue manner or in a interfaith dialogue or in a peaceful manner. You can communicate with them whatever is your belief. Then you have the right to preach, and second one, you have the right to practice whatever you believe. And different religions have different practices, different celebrations, different dress codes and different things are there associated with the religion, because religion is a part of the culture. Then it will have some particular practices would be there for each and every religion associated with the institutions of the religion or associated with the daily life practices, also marriage and wedding. And every religion will have their own different practices related to wedding. Then all the individual in India is permitted or can follow, has the right to practice his own religion. Then preach, practice, and third one, to propagate any religion. Propagation means, propagation does not give the right to convert other person, and you have the right to propagate to him and tell him that these are the basic philosophy of the religion in which I am believing. I believe that that is true, and I believe that this faith is completely honest and true faith. If you want, you can follow. If you don't want, you don't follow. Then that is the propagation. Otherwise, encouraging another person or giving some emoluments to another person, giving some gift to another person and purchasing the consciousness of that person is not constitutionally permitted. Everybody has their own self. Let them follow their self. If somebody wants voluntarily to change their self, then that is permitted. Otherwise, forcefully, either it is through by using the coercive force or by using the stimulating forces or by using the encouraging forces, that is not permitted. And propagation, the meaning of the propagation is that peacefully transferring the ideas you believe in into the other people or the fellow citizens. Then conversion should be a freedom, a decision of the self, not by the encouragement or by the force of another person. Then Article 25 tells that everybody in India has the freedom to preach, to practice and propagate the religion. And the most important feature is that this is an individual freedom and not to a group. And every individual has the freedom to or the right to preach, practice and propagate any religion in which he is believing in. And next is that 26. 26 is that Article 26 talks about freedom to manage religious affairs. Freedom to manage religious affairs. Religion, it will not be only, it is not something which is limited to an individual. Sometimes there will be some collective practices of the religion, some festivals associated with the religion and some other processions, some other practices, some prayers may also be the collective prayers. The group of people together are doing their worship, their prayer, their festival or their practice. Then if a group of the believers who are believing in a same faith or a same religion, they have the right to manage the religious affairs. If a particular religion, they have a place of worshipping, then they have the right to or they have the freedom to manage the place of the worship. They can have a committee to manage it, they can have a particular system to manage it, they can have some office staffs to manage it, then that is according to them. And all the religious groups in India have the freedom to manage religious affairs. Then the most important portion is that this is the right to manage religious affairs, whether it is a festival or whether it is a religious institution. From the term itself, you can understand that this is not an individual freedom, this is a collective freedom. Then Indian Constitution or the fundamental rights of Indian Constitution guarantees both individual religious freedom and collective religious freedom or the collective right also. As a group of people, a religious community or a believers in a particular faith, as a group they have the freedom or they have the right to manage their religious affairs, and each and every individual as an individual, he has the freedom, he has the right to preach, propagate and practice any religion. Now the third one, Article 27. 27 discusses about the taxation, whether religion can be taxed or not according to the Constitution of India. And 27 tells that no tax can be levied for promoting a religion, and whether it is any group of believers, whether somebody who are not believing in any God or any religion, they have also some faiths that is not believing in God, and even those group of people, whoever is, they have a particular faith or they have a particular religion, they should not be levied any tax for promoting any religion. For example, somebody is a group of people, they are promoting a particular religion, then government cannot levy a tax, tell them that for the work you are doing here, because everything is taxed in India now. Goods taxed, service taxed, GST came and goods and services are taxed, then you cannot interpret that promotion of this particular religion is a service and pay some taxes for that. Then the religious promotion or no tax can be levied for promoting any religion in India. That is the Article 27, no tax for promoting a religion. But at the same time, something has to be taken care of, that there is no tax. Tax means that and this much percentage or this much money you have to pay as a service or as a tax or as a charge for doing this particular, providing this particular product or service or earning some income, something else. Then anyway, there is no tax. But sometimes at the same time, and government expenditure, no government expenditure can be done for promoting a religion or for favoring a particular religion, promoting this particular religious ideology. The government believes that this is the right religion Indians should follow. Then for promoting that particular religion, for spreading the ideas of that particular religion, the Constitution under Article 27 tells that another clause is that no government expenditure for promoting a particular religion. Then in the beginning itself, while explaining the meaning of secularism, we explained that government or the state should have equidistance towards every religion. Then making a government expenditure for promoting a religion, that is the violation of the constitution. But sometimes government may give some financial assistance for the pilgrims and for some other people who are going for the pilgrimage, then government may give some financial assistance. It is not for promoting the religion, and the aim is that for assisting some poor people who want to go for their for a pilgrimage according to their religious faiths. Then all the pilgrims in India who are going for a pilgrimage outside India, they have some particular subsidy is given. And the point is that that is not coming under the expenditure for promoting a religion. That is different. Making an expenditure for propagating a religion, spreading a religious ideology, for converting the Indian people into that particular religion, that is against the constitution. But helping some poor people for fulfilling their dream to do some kind of pilgrimage does not come under the Article 27's prohibition. Then government expenditure cannot be done. At the same time, sometimes government may charge some fee from the pilgrims. If some foreign pilgrims are coming to India, or some pilgrims are going from one place in India to another place, sometimes there may be some government charges or government fees may be there on the pilgrims and on some religious endowments also. Somebody is running a religious charity organization, government fees may be there, but tax cannot be there. Another group of the people, they want to make a procession of the religious procession or something related to religion, they want to make a conference. Then if that particular conference makes some environmental hazards, then government may charge something from the people who are organizing that conference. That is not against the religion. Government is not working against whoever is making that type of programs, government may charge from them. That is not considered as a tax. It is only a fee implemented on organizing a program or doing some kind of pilgrimage, or some temples may be there under the government. It is or some mosque may be under the government. Archaeological Survey of India may have some old monuments that is associated with some religious groups. But sometimes the archaeological survey or government may make some entry fees into that archaeological monument which is associated with some religion. Then government may charge some fee from the pilgrims or and religious endowments for some particular activity they are doing. Then for promoting a religion, there would be no tax. For some particular activity like migration, there may be some fee is permitted for pilgrimage and from religious endowments. And if a religious endowment is working, then government can charge some kind of fee from them, but there should be no tax for promoting a particular religion. Now the last and final article in this group, freedom of religion or right to religion, the Article 28. We can check what is Article 28. Article 28 discusses that we know that most of the educational institutions in India or the large number of educational institutions in India are run by the government or getting aid out of the government. Some aided educational institutions would be there. The institution was established by some private people, but the government gives the aid, the salary, allowances of the employees and other aids are given by the government of India. Then the 28th one is that we want to keep our educational institutions in a secure manner, secular manner, not in a secure, in a secular way. We want to give the education to the children of India or the students of India. Then everybody who is going to any school, they have the freedom from attending religious education, religious instructions in educational institutions. Then freedom from attending religious instructions in educational institutions. If some educational institutions are giving religious instructions, only if the students they wish to participate, they can participate. Otherwise, if the students are minor students, their father or parents, their parents should wish them to participate. Otherwise, nobody should be forced to participate in any religious instruction in any educational institutions against their will or against the will of their parents if they are minor children. Then no person should be forced to attend, and everybody has the freedom from attending religious instructions in educational institutions. That is the Article 28. But this is implemented, this is applicable only to the educational institutions under the government of India and the educational institutions which are getting aid out of the government funds. Some exception is here also. Some educational institutions may be under the government, but the educational institutions basically it was established for the empowerment of some kind of religious groups. For example, the Banaras Hindu University. It was established by Madan Mohan Malavya and other leaders of the Hindu community for giving education to the Hindu community. That is the aim. But presently it is a university under the government of India. Jamia Millia Islamia, Aligarh Muslim University were established by Muslim leaders for promoting education among the Muslim community. Now both of them are under the central government of India. Then this provision is not applicable in government institutions established under any religious endowment. Then the exception here is that some institutions are exception, they can have the religious instructions, and the main thing, the major exception is that educational government institutions, they are government institutions now run by the government, but originally they were established under some religious endowments. Then government institutions established under religious endowments, then such institutions are exempted from the Article 28, that is the freedom from attending religious instructions in the educational institutions. Now the next group of the fundamental rights. The eighth portion of the eighth classification of the fundamental rights is cultural and educational rights. It has two rights but mentioned in a single article. One is cultural right and a second one is educational right of the people of India. We can check what are the cultural and educational rights ensured by Part 3 of the Indian Constitution, that is fundamental rights. Article 29, only one article is mentioned under this category, that is Article 29. Article 29 gives two rights, that is one is cultural right, second one is educational right. And Article 29A that discusses about the protection of interest of the minorities. Many different minorities are there in India. Minorities are not only the religious minorities. Some cultural minorities are also there. Then this Article 29 discusses about the rights of the cultural minorities. That is the most important thing, and it concentrates, specifically focuses on the rights of cultural, linguistic and scriptural minorities in India. Then 29A is the protection of interest of minorities. Protection of interest of minorities. Minorities, Constitution tells that protection of the cultural interest of the people, and it gives protection for the people, cultural interest of the people having a distinct language. Either the people becomes minority because their language is minority language, very few people are speaking that language. Then protection of the cultural interest of the people having a distinct language. Second one, either otherwise having a distinct script or having a distinct culture. Then it should be the Constitution ensures the protection of the culture of or the protection of the cultural interest of any group in India or any minority group in India. They are minority, culturally minority, because they have a distinct language, because language is a part of the culture, and script, they have a distinct script, then they became the minority of people who are writing in that particular script. Then they become minority, they are a cultural minority having a different script, and otherwise they are a minority having a different culture. Then it is the duty of the state in India to ensure that protection is given to all these cultural interests of the minorities. They will have some interest. If a minority is there, imagine they speak a particular language, some tribal people, very few number of people would be there living who are speaking that particular language. Then they have a cultural interest. Our language has to be protected. Then the government of India has to take the initiative to protect the language of that cultural minority or linguistic minority. Second one, if there is a group of people, a very minute microscopic minority group of the people who are writing in a particular script, then the government has to take initiative to protect their scripts, because it is a part of protecting their cultural interest. And likewise, if there is a group of people having a distinct culture, whether it is material culture or social culture. Material culture means that having a distinct dress code. Some people may be with turban or some other particular and very odd dress codes. Then they are also a cultural minority having a distinct dress code, sometimes a distinct style of life, belief, and social institutions like family, wedding, marriage. All these things are a little bit distinct or much different from the mainstream society in India. For a minority community, if they want to protect their cultural interests, the government has to ensure that they are given, or their cultural interests are given, adequate protection, social protection. That is the first part of the cultural rights. Under Article 29A discusses about this cultural act, cultural right. Then second one, 29B discusses, it is also another second portion of Article 29. 29B ensures some educational rights. 29B talks about, we told that the heading itself mentions that Article 29 has two portions. One is cultural right, another one is educational right. Then obviously 29B would be talking about the education. Then 29B tells that no person shall be denied admission to educational institutions based on religion, race, caste or language. That is, when a child is going to take, a parent is going to take admission for his children or for his child in a government educational institution or in a private educational institution which is receiving aid out of the government fund. As I told you, some aided private schools would be there, aided private educational institutions would be there. Then either if it is a government institution or if it is an institution receiving aid out of the government funds, then such type of institutions cannot deny the admission to any children or any students, telling that or explaining that he is belonging to a particular religious community, or he is from a particular race, and or he is from a particular caste, or he is speaking a particular language. Then on the basis of language, caste, race or religion, no person shall be denied admission in any educational institution. Then 29B talks about no denial of admission in educational institutions, whether it is a school or college or university. No person shall be denied the admission on the following grounds. We can check what are the grounds. On the grounds of and no denial of the admission in educational institutions on the basis of religion or on the basis of race, caste or language, or he is speaking a particular language. Then On the basis of these 4 criteria, nobody should be denied admission in any educational institution which is completely run by the government of India or government of any state in India or receiving aid out of any government body in India. Then such institutions have to give the admission irrespective of the religion of the students, the race of the students, caste and language of the students who are seeking admission in that particular institutions. The next classification of the fundamental rights, that is the 9th group of fundamental rights, is right of the minorities to establish and administer educational institutions. Minorities in India, they have some right to establish their own educational institutions. Simply we can call it as right of minorities. And the right of the minorities as mentioned in Article 30 is limited to establish and administer their own educational institutions. That is why you must have seen when you are traveling across India, you can see the Christian management schools, Christian management colleges and Muslim management schools, Muslim management colleges in large number, because the minorities have a special right in India to establish their own educational institutions and administer their own educational institutions under Article 30. We can explain that. Article 30 gives this right, and under Article 30 all the minorities in India. Then the word minority is not limited to religious minority. Whether they are religious minority or linguistic minority, then under the right given in Article 30, both religious and linguistic minorities are involved. Then both the religious and linguistic minorities in India, and all the minorities, whether they are religious minority or linguistic minority, can establish their own educational institutions. They can establish their own educational institutions, whether it is a school, whether it is a high school, whether it is a higher secondary or college level. They can establish their engineering colleges, medical colleges. You can see many medical colleges and engineering colleges in the name of some particular minorities, because they have the right under Article 30 to establish their own educational institutions. And another thing is that while giving, if the state government is giving some fund for the educational institutions, they should not, or granting some aid, or the higher educational department in India, if they are giving some kind of particular aid or fund or grants to the educational institutions, then state shall not discriminate such institutions in granting the aid. If they are giving to everybody, it has to include all the institutions established by the minorities as well. If they are not giving to any private institution, then they can exclude the private minority managed or minority established educational institutions also. And in another way, if the government is giving some aid to private institutions, then they should not discriminate any private institution which is managed and established by a minority in India. The second clause of the Article 30 tells that no discrimination by the government, no discrimination by the government towards these institutions in government grants, in giving grants by the government, these institutions should not be discriminated. Then Article 30 very clearly tells that all minorities, whether they are religious or linguistic minorities, they have the right to establish their own educational institutions. Second thing is that, and while giving a grant from the government funds, such institutions should not be discriminated because they are minority established institutions. Now the next group of fundamental rights, that is Article 31, the right to property. Earlier it was there, and we are discussing now the 10th classification of the fundamental right, that was, because presently it is not there in the constitution, it was right to property under Article 31. But by the 44th Amendment Act of the Indian Constitution, it has been deleted from the group of the fundamental rights. Now, the right to property is not a fundamental right when the government of India introduced the land reforms. Because land reforms means that many people were there in India even without a small piece of land. At the same time, on the other side, many people were there with large acres of land, large area of the land. Then through the land reforms, government has confiscated the land from the people who have a land surplus, and it has been distributed to the people who does not have any piece of land. Then to do that, because if the Article 31, right to property, if it is a fundamental right, government will not be in a position to take the land or confiscate the land from the people who have that property. They can claim that my fundamental right has been violated. Then for protecting that, we will discuss that in detail in other portions of the Constitution. For protecting that, the 44th Amendment Act of the Indian Constitution in 1978 has abolished the right to property as a fundamental right. It has been deleted. The Article 31 was deleted and another article was added. Article 300A was added as a was added in the Constitution. Now Article 300A talks about the right to property, but it is not a fundamental right. It is only simply a constitutional right. Constitutional right, the value of the constitutional right is below the fundamental rights. Then now at present in the Indian Constitution, there is no right to property as a fundamental right. Right to property is simply a constitutional right mentioned in Article 300A. That is why that is not the 10th classification. Originally in the present Constitution, the 10th classification of the fundamental right is the right to constitutional remedy. This is very important because we already discussed that fundamental rights are justiciable rights, that if somebody is not getting the fundamental rights, they can claim that either in the Supreme Court of India or the High Court of India. You can move to the Supreme Court and High Court and file a complaint, my fundamental right is denied. Then how you can move, that is discussed in the right to constitutional remedies. The Constitution itself makes some remedial measures for the people who are denied their fundamental rights. Then if a person is denied his fundamental rights, the Constitution itself in the Article 32 suggests that what are the remedial measures, how you can get the justice if the fundamental rights are denied. Then this is discussed in the Article 32. Article 32 discusses that there are 5 writ petitions. For moving these writ petitions, if somebody is denied their fundamental rights, they can move either to the Supreme Court of India or the High Court of India, High Court of any state through 5 different writ petitions. Then these 5 writ petitions are discussed in the Article 32 for reclaiming the fundamental rights or redeeming the prevented fundamental rights. Any individual in India or group of individuals in India can move to the Supreme Court or any High Court in the form of 5 writs. That 5 writs are mentioned in the Article 32. We are going to discuss all the 5 writs mentioned in the Article 32 one by one. As I told you, the Article 32, it includes 5 writs. All these 5 writ petitions can be used for reclaiming if somebody loses and somebody is prevented their fundamental rights. We can look what are these 5 writ petitions. One is habeas corpus. Habeas corpus. And what is the literary meaning of the habeas corpus? Habeas corpus. Corpus means the body. Habeas means to have the body, to bring the body. Imagine that. Normally habeas corpus, it is a common writ issued many large number of times in India. It has been issued in the past also large number of times, and presently also it is being continuously used to issued, and it is continuously being issued by by the different people, they are filing petition under the habeas corpus either in the Supreme Court or the High Courts in India. And habeas corpus means, from the word literary meaning itself we can get what it is. Habeas corpus means to have the body of, or to bring the body of. The point is that if somebody is missing, imagine that somebody is missing, then they are suspected to have been illegally detained by another person. Another person has kept in illegal custody and he is not permitting the person to move outside, because right to move, freedom of movement is a fundamental right. Freedom of movement is denied. Right against arrest and detention, no person can be detained illegally, then that also denied for that person. Imagine somebody is missing and it is suspected by the parents or the relatives or anybody else that person is illegally kept in confinement or illegally kept in custody by another person, then that parents or the relatives of the person, they can move this particular writ petition that is called as the habeas corpus. Habeas corpus means it is issued for releasing an individual who is kept in the illegal custody or illegal confinement. Then they can move to the Supreme Court or High Court and tell that my daughter is missing, or my son is missing, or my brother is missing, and please file a writ petition in the name of the habeas corpus to produce that body. If they again complain that it is suspected that another person with this particular name or this particular person has kept my relative in the illegal confinement, then the Supreme Court or the High Court will order that person, you bring the body of the another person in front of us. Then Supreme Court will directly ask the person, are you kept in illegal confinement, or are you residing with him, or are you living with the another person according to your personal will, or the person has kidnapped you or keeping in illegal confinement. After listening to the person who is accused to be illegally confined, the Supreme Court and High Court will take a decision. If the Supreme Court feels or High Courts feel that the person has been illegally confined, then they will release the person, and if they feel that the person has gone with the other person according to their personal will, then they will be allowed to, the person will be allowed to do according to his personal will. Then that is the habeas corpus. Second, writ. And one more point is that this habeas corpus is known as the bulwark of individual liberty. In the constitutional study, it is called as the bulwark of individual liberty. Bulwark means the custodian. It is the protector of the individual liberty, because an individual has the freedom and to move anywhere, freedom against the detention and arrest. Then if somebody illegally confines that person, using this writ petition, the courts of India, the higher courts of India will release that person. That is why this writ petition helps other person to regain his own personal choice and to regain his own, to come out of the illegal confinement or to go according to his will and wish. That is why it is known as the bulwark or the custodian of the individual liberty in India. Now we are moving to the second petition. We already told that there are 5 petitions or 5 writ petitions under the Article 32. The second one is mandamus. Mandamus, the meaning of the word mandamus is that we command. We command, it is included in that itself. We or the higher authority, here the we is that the Supreme Court or the High Court. We command to a lower body, you do this or do not do this. It is issued from asking a public body to perform its duty. Imagine that one public body is not performing their duty. As the public body is not performing the duty, the individuals of the country or the people of the country are losing their fundamental rights. We have a fundamental right. For example, we have a fundamental right to life. Life is also, that is, the Supreme Court has interpreted life with dignity. Imagine that the municipality where we are living, the people who are working or the workers of the municipality who are picking up the waste from our municipal area, they went for an indefinite strike. Then nobody picks up the waste. The whole waste is accumulated in the places nearby the house, nearby the buildings, inside the market. Everywhere the waste accumulates, then that means that the public authority, which is a municipality, is not performing their duty. That is why there is a threat for our life. Some communicable diseases may come up, some other health issues may come up, and people may die out of these health issues. Then as a public authority is not performing their duty, there is a threat to the fundamental right of the people of India, that is their personal right, freedom of a right to life and personal liberty, or protection of life and personal liberty. Then we can move to the High Court and Supreme Court and ask the High Court and Supreme Court, you please order this particular government authority or public body to perform their duty and regain our personal fundamental rights. Then the concerned court, whether it is High Court or Supreme Court, they will issue a writ petition called as mandamus, that we order the particular public authority, you perform your duty. Then this is used, the second one is used for making an order to asking a public body to perform their duty. It is issued towards a public body, and the purpose is that they are demanded to, or they are commanded to perform their duty, and this is the benefit, this is the aim of, this is the essence of the mandamus writ. Then we are moving to the next. Now the third writ is prohibition. Prohibition, all of you know what is the meaning of the prohibition. Prohibition means that to forbid, don't do. Third writ under Article 32 is prohibition. Prohibition means to forbid. Then preventing somebody from doing something, that is prohibition. Here it is issued by a higher court, whether it is Supreme Court of India or the High Court of any state. Then issued by a higher court to a lower court. Lower court may be district courts or the municipal courts, and some other tribunals may also come under the category of the lower court. Some river water dispute tribunal. Tribunal is a temporary court established for a particular purpose. If there is a river water dispute between two states, then to solve that there would be a river water tribunal. Kaveri River Water Tribunal and Satluj River Water Tribunal. These are only for solving that Satluj river water dispute between Punjab and Haryana, or the Kaveri river water dispute between Tamil Nadu and Karnataka. Then a higher court issues this forbid to a lower court or a tribunal for exceeding their jurisdiction. Imagine that the lower court is involved in a case on which the lower court has no jurisdiction. Jurisdiction means the power to make a judicial verdict or the power to do the justice, and it is out of their power. The particular case is supposed to be made supposed to come under the jurisdiction of the High Court or the Supreme Court of India. Then if they are, for example, any constitutional dispute, it is the power of the Supreme Court of India. And if any district court is dealing with any constitutional disputes, then the Supreme Court of India or the High Court of India may issue a writ called as the prohibition to the lower court, telling them, you don't make the jurisdiction on that, transfer the case to us. It is our jurisdiction, it is in our capacity, we will make a judgment on that. Then the prohibition is issued by a higher court to a lower court, issued by a higher court to lower court, and the thing is that the goal is that for exceeding their jurisdiction. When the lower court exceeds, they exceed the jurisdiction, they are going beyond their jurisdiction power, then the higher court will issue, they exceed their jurisdiction, the higher court will issue the prohibition to the lower court, telling that we are forbidding you from making a jurisdiction, it is not coming under your jurisdiction, that is why transfer the case to the concerned court, and which comes under their jurisdiction. Then that is prohibition. And next, the fourth writ petition under Article 32 is the certiorari. Fourth one is certiorari. Certiorari means that to be certified or to be informed. And to certify, that prohibition we told to forbid. Then here the meaning is to be certified, or another meaning is that to be informed. Then again, this is also a writ issued by the higher court to the lower court, and issued by a higher court to lower court to transfer a case. Sometimes the lower court may have the jurisdiction, but the higher court thinks that it is better to transfer this case from this court to any other court, because this court may not be able to do the justice in this case. It may be due to the use of excess jurisdiction or lack of jurisdiction. I can explain to you. Excess jurisdiction we already discussed, and certiorari may be the lower court is using excess jurisdiction on that particular case. That is why you transfer, that is beyond your jurisdiction. Another thing is that lack of jurisdiction. The court has, Supreme Court, for example, in the case of Jayalalitha and Shashikala, the case was transferred from the Madras High Court to Karnataka High Court. Why? There was a complaint. The case was in Tamil Nadu and the alleged corruption was in Tamil Nadu, and that is why now Shashikala, the close associate, close aide of Jayalalitha, is in jail. Then the case was in Tamil Nadu. Why the case was transferred from Tamil Nadu High Court to the Karnataka High Court? There was a petition in front of the Supreme Court. There is a law chance to have a justice in this case if the case is run in Tamil Nadu, and if the person is kept in Tamil Nadu jail also, if the person is getting punished after the case. If she is kept in Tamil Nadu jail, there may be a problem of law and order, because the person is a great leader of Tamil people. Then there is a chance of having a law and order issue. Then better to transfer the case from Tamil Nadu into Karnataka. That is why the Shashikala's case was transferred from Tamil Nadu to Karnataka, and the Karnataka High Court has given the judgment, and they are kept in the Karnataka jail itself. Then the point is that certiorari, if there is a chance that a case is running in a particular case, there will be lack of jurisdiction would be there, then also the higher court has the authority to transfer the case from a particular court to any other court, or quash the case. Quash means stop the case for a while. Don't go ahead with the procedures until and unless we make a second order, you quash the case. Then that is also called as the certiorari. Certiorari means that to be certified or to be informed. Inform us, or we want to give you a certificate whether you can continue with the case or you have to transfer the case. It is issued by a higher court to a lower court to transfer or quash a case. It may be due to the use of excess jurisdiction or the lack of jurisdiction, as I explained now. And the last and final one, the fifth writ petition under Article 32 is the quo warranto. Quo warranto means that on what authority? We are asking to some person, why are you here? On what authority you are here? It is, the point is that if somebody is suspected or some other person believes, we have already discussed that there should be equality in the public employment. Under Article 16, any person has to have the access to the public employment without any discrimination. That is why public employment should be a merit-based employment. Whoever are getting higher marks, and otherwise whoever are getting the legal reservation, they have to enter inside the public service. Now, if somebody is suspected that he does not have the eligibility to enter inside a public service, but the person has assumed that public office. Somebody is suspected that by cheating in the examination, the person has qualified the civil service and assumed the service, or by giving some bribe or influencing the examiners. A person through a corrupt method he has entered into the civil service or the public employment or bureaucracy. Then this particular writ will be issued other person if it is suspected that he does not have the enough educational qualifications to be elected as an IAS officer or a civil servant, because minimum qualification should be the undergraduate degree, and it is suspected that the person does not hold an valid undergraduate degree certificate. Then this writ will be issued against that person. Then this is a writ, it is issued as a part of enquiry by a court into the legality of the claim of a person to a public office. There is a suspicion whether this person has assumed this office through a legal method or through an illegal method. Then to verify that, the Supreme Court will issue a writ named, or the high courts in India can issue a writ named as quo warranto, and this is asking the person on what authority you have assumed the public office. If there is a doubt on the undergraduate degree of the person, the court will ask the person, you bring your original certificate, let us verify that. If there is a suspicion on the cheating in the examination hall, then the court will ask the police officers concerned who made the inquiry, you bring the documents, let us verify. Then this is an writ, it is issued as a part of enquiry by a court into the legality of the claim of a person into a public office, but it cannot be issued against the ministerial office or the private office. The court cannot ask a particular minister on what authority you are sitting in that ministerial job or the ministerial position. It is not a job, it is a position. And another one, a private office, the managing director of the Reliance. The court cannot ask that person what is your authority to sit as the managing director of the Reliance company. Then that is a private thing, only public, that also an employment, not a political position of a minister or any other. Then it can be issued only against a person who assumes a public office as an employment or as a state or central service through an illegal method or through a malified method or a cheating method. It can be issued against that person. As a part of the inquiry, the court demands the person prove your authority inside this office. By this, we have finished the classifications of the fundamental rights. Now we are moving into the conclusion part of the fundamental rights. In the conclusion part, the next article, Article 33. Article 33 discusses about the fundamental rights and the armed forces. How the fundamental rights should be given for the armed forces? Is there any restriction for the fundamental rights and armed forces? Armed forces, it includes the Army, Navy and Air Force of India. Is there any restriction, or is it possible to bring some restrictions or apply some restrictions on the fundamental rights of the armed forces, because it is a very strategic job or a strategic wing of the government. Then Article 33 tells that Parliament can make restrictions on the fundamental rights for the armed forces. It is possible for the Parliament, then the authority to make some restrictions on the fundamental rights of the Indian armed forces is only Parliament. Parliament can take a decision. Armed forces have some restrictions. They could not speak everything in their mind. They have to keep some secrecy. Official secrecy would be there. Then they cannot tell everything inside the Facebook or Twitter or any other social media, telling that we also have the freedom of expression as ensured in Article 19. Parliament can make some restrictions. Then another important thing is that while making some restriction on the armed forces, it would not be applicable only to the Jawans, soldiers, colonels, majors, but some other group of people are also there inside the army. Some barbers should be there in the army, carpenters should be there in the army, cooks will be there in the army, and more religious instructors would also be there inside the army. Then all the people working inside the army, it would be applicable for them. Any restriction made on the fundamental rights of the armed forces by the Parliament of India is applicable to each and every person who is working with the armed forces or Indian military, and it is applicable for each and every servant inside the armed forces, including soldiers and or the army persons, army jawans, army persons, it is very clear, but including the barbers, they will also have the restrictions. Second one, if there are some carpenters in the army, it is applicable to them also. And third is the cooks inside the army, and the fourth is religious instructors in the army. It is applicable to each and every person employed inside the army. Next is Article 24. Religious instructors, these are the four groups, and if any other person working with the army, also some security guards inside the army, some other transporters, drivers inside the army, applicable to each and every person who is working inside the army. The next portion is that fundamental rights and the martial law. During the martial law means that in an area, any area in India, if there is a crisis, public uprising, public crisis or internal rebellion, then army may take over the administration of that area. That situation is called as the martial law. Then Article 34 discusses about the fundamental rights during martial law. Then fundamental rights and martial law. During the martial law, when the army becomes the rulers of a particular region in India, in some particular circumstances, whether there would be some restrictions on the fundamental rights. Then Article 34 tells that restrictions on the fundamental rights can be implemented when a territory is under the martial law. Then there can be restrictions would be there if the area is under the martial law. But one more thing which has to be noticed is that the term martial law, if you search the whole constitution of India, you cannot find the term martial law any place other than the Article 34. Then Article 34 is the only article that mentions that India can be sometimes under the martial law. Then the martial law of India, that it is possible for the army to take over the administration of any region in India if there is an extraordinary circumstance or extraordinary crisis, and that is also mentioned in the Article 34. Basically, Article 34 talks about the fundamental rights during the martial law. Then the word martial law is mentioned only inside the Article 34 in the whole constitution. Then martial law is also mentioned. Sometimes question comes, which part of the Indian constitution mentions the martial law? Then part 3, fundamental rights, under Article 34 mentions about the martial law. Martial law was borrowed from the English common law. English common law has the provision for the martial law. Then this martial law, the idea of the martial law is borrowed by the Indian constitution from the English common law. In the English common law, Britain, if there is any crisis in any region, according to the English common law, the martial administration or martial law can be implemented. Now, final and the last article in the part 3 of the Indian constitution under fundamental rights, that is Article 35. I already discussed with you. Article 12 to 35 discusses about the fundamental rights. Then we can look what is there inside the Article 35, that is the last article in the chapter of the fundamental rights. Article 35 tells that how the fundamental rights would be implemented. Then 35 tells that some fundamental rights are self-implemented only because it is a fundamental right mentioned in the Constitution of India, it has to be implemented. But some other fundamental rights are implemented by an act of parliament. Then some fundamental rights we can classify them generally into two: the self-implemented fundamental rights, another one implemented by an act of the parliament. Then fundamental rights can be either self-implemented or can be implemented by an act of parliament. In two ways also it can be implemented. Even if there is no parliamentary law to implement a particular fundamental right, it has to be again implemented as a fundamental right mentioned in the part 3. If there is a parliamentary law, because parliamentary law will make sure that adequate punishment is given to a person violating this fundamental rule. What is the punishment? Whether it is 3 years, 4 years, that would be mentioned in the parliamentary law. Then fundamental rights can be implemented both by the parliamentary act as well as in a self-implementation method. And again it tells that parliament can make laws for implementing the fundamental rights, and there is no such power for the state government. State governments cannot, or state legislative assembly cannot make any law for implementing the fundamental rights. Only parliament can enact, or parliament can legislate for implementing fundamental rights. At the same time, no state government in India cannot legislate. This power is not given, it is not for state legislative assembly. Only parliament in India can make a law or make an act for implementing the fundamental rights according to Article 35. If the parliament is not making any act for implementing a particular fundamental right, that would be self-implemented only on the merit of being a fundamental right mentioned in the part 3 of the Constitution. Now, while concluding, I want to share some common points about the fundamental rights. 1. Fundamental rights. Whether fundamental rights can be amended. We already discussed that Article 31, which was earlier the right to property, was deleted. Then the amended question, whether any part of the fundamental right can be deleted from the Constitution or changed by a parliamentary act or a Constitution Amendment Act. That is the first discussion. Then the first point I want to share is that fundamental rights can be amended, but there are some restrictions. There are some features of the Indian Constitution. They are called as the basic structure or basic features of the Constitution. For example, democracy. Around 21 basic features are there in the Constitution of India. Democracy, India is a democratic state, and secularism and democracy, secularism, republic, sovereignty, welfare state, and continuously, etc., etc. There are around 21 basic structures. That is the base of the Constitution. And for a house, for a building, we will make a base first. After that, we will make the periphery. Then if the base collapses, the whole building collapses. Then India has some basic fundamental principles or fundamental philosophy that India is a democratic country, never a theocratic or aristocratic country. India will not have a king, it will only have an elected prime minister. It will only have an elected prime minister. And that is the base of India. If the base is deleted, then the complete India, the periphery of India will completely collapse. That is why basic features, if any fundamental right is mentioned in the basic feature of the Indian Constitution, for example, Article 32 is mentioned, the constitutional remedies, right to constitutional remedies is mentioned as a basic structure of the Indian Constitution. Then the basic structure we will discuss in detail later in the class on the amendment of the Constitution and basic structure. We have a separate class, there we will discuss. In a controversial case named as Keshavananda Bharati case, the Supreme Court has introduced this limitation on the amendment of the Constitution. You can amend the Parliament of India, both Rajya Sabha and Lok Sabha separately can amend any part of the Constitution except the basic features of the Constitution. The basic features will be listed out by the Supreme Court of India. Supreme Court of India will list out these are the basic features. Those things cannot be amended. Other portions of the fundamental rights can be amended. Then fundamental rights can be amended. The only restriction is that any basic feature of the Constitution or basic feature of Constitution inside the fundamental right cannot be amended. That is not amendable. Next is The second point is that fundamental rights are justiciable rights. Justiciable means that if somebody is denied the fundamental right, he will get the justice. As I told you while describing the Article 32, the fundamental rights are justiciable. That is why Article 32 itself made some mechanism how to get the justice if somebody is denied through the form of 5 writ petitions: habeas corpus, mandamus, certiorari, quo warranto and prohibition. These, in the form of these 5 writ petitions, the Constitution itself has made a mechanism to ensure that fundamental right, nobody should be denied the fundamental rights. If somebody is denied, they can claim back their fundamental right going to the courts in India. That is the meaning of the fundamental rights are the justiciable rights. And the third important feature of the fundamental rights is that it is called as the bedrock of democracy. The bedrock, in the geography or geology, will study about the bedrock. Then bedrock is the base of the rock. Then the bedrock of democracy. Democracy in India and any country, democracy can live. Democracy can be implemented by ensuring certain rights to the citizens of the country. That is why the fundamental rights can be called or defined as the bedrock of the democracy in the country. Next is that whether it is applicable to the foreign citizens also or only for the Indians. If a foreigner is there in India, whether he will get some fundamental rights or not, then fundamental rights, there are something which is available only for the citizens, some other things are available on both for the citizens and aliens, foreigners who are inside in India. Let us first discuss only for citizens. Which are the fundamental rights ensured only for the citizens of India? Those who have a passport or an election ID in India, they can be called as the citizens. Then some fundamental rights, Article 15, Article 16 and Article 19, 29 and 30. These 5 articles are ensured or guaranteed only for the citizens of India. We can check what is Article 15. Article 15 is that prohibition of the discrimination on the basis of caste, creed, gender and place of birth. On the basis of the place of birth, no Indian will be discriminated. Sometimes an alien person, a foreigner coming to India may be discriminated on the basis of the place of the birth. Second one, 16, prohibition of the discrimination in the public employment. No person from outside India cannot claim that I have also the equal access to the Indian administrative service, I want to appear the examination. That right would not be given to an alien. Or equality or prohibition of discrimination in public employment and equality of the opportunity in public employment mentioned in Article 16 is ensured only to the citizens of India. 19, freedoms. All the 6 freedoms we discuss: freedom of speech and expression, freedom to assemble anywhere peacefully without arms, freedom to form association, freedom to move anywhere, freedom to reside anywhere, freedom to do employment anywhere. These 6 freedoms mentioned in Article 19 is also available only for the Indians. Next is Article 29. Article 29 is the cultural and educational rights of the cultural and educational rights. We discussed that for the minority, linguistic, scriptural or cultural minority, they have the right to protect their particular culture. Then nobody should be denied admission in any educational institutions on the basis of religion, race, caste or any other thing. Then that is also available only for the Indians. And Article 30 is the right of the minorities to establish and administer their own educational institutions. That is also available only for the Indian minorities. Then Article 15, 16, 19, 29 and 30 are available, are guaranteed only to the Indian citizens. All other articles starting from 12 to 35, you exclude only these 5. All other articles are guaranteed to both citizens and aliens or the foreigners who are inside the geographic territory of India. Now, so far we have discussed all the 10 classifications of the fundamental rights. Let me make a small review or a summarized review of all these 10 classifications. First one was right to education, right to equality. Right to equality is mentioned in Article 14 to 18. 14, equality before law and equal protection by law. 15, prohibition of discrimination on the basis of caste, creed, gender and place of birth. And 16 is that equality of opportunity in public employment. 17 is abolition of untouchability. 18 is abolition of the titles. Next one is that second group of the fundamental rights is that right to freedom. Right to freedom is mentioned in Article 19 only. 19 talks about the 6 freedoms which I mentioned just now. And third one is protection in respect of conviction of offences. While somebody is convicted of offences, their protection in respect of conviction of offences is mentioned in the next classification, that is mentioned in the Article 20. Article 20 mentions about that. We already discussed that in detail. 3 protections are there: no ex post facto criminal legislation, and second one is that no self-incrimination, and the third one is no double jeopardy. And the fourth category is that right to life or protection of life and personal liberty. The fourth one is protection of life and personal liberty. That is the fourth classification of the fundamental rights mentioned in Article 21. Then fifth one and 22, Article 22 discusses about the right against arrest and detention. We already discussed that what are the rights of the people who are arrested under ordinary law and what are the rights of the people arrested under the Preventive Detention Act. Then right against arrest and detention, that is the fifth category of the fundamental rights. Now we can move to the sixth one. The sixth one, we discussed that Article 23 and 24 discusses about the right against exploitation. Rights against exploitation is the Article 23. 23 prohibits the human trafficking and beggar, and 24 prohibits the child labor. Then this is the sixth category, and seventh is that right to freedom of religion. Then from 25 to 28, articles from 25 to 28 mentions about the right to freedom of religion. 25 tells that every individual in India has the freedom to preach, practice and propagate any religion. 26 tells that every group in India have the freedom to manage their religious affairs. 27 tells that nobody will be taxed for promoting any religion. 28 tells that no person should be forced to attend religious instructions in any educational institution either run by the government or receiving aid out of the government. Next is that the eighth category is that right of the minorities and cultural and educational rights. Cultural and educational rights of the minorities is mentioned in the Article 29. We told that linguistic and cultural minorities, they will get their right to protect their particular language, script or culture, and no person shall be, educational right means that no person shall be denied admission in any government run or any educational institution receiving aid out of the government on the basis of religion, race or caste. And next, the ninth category of the fundamental rights is that right of the minorities to establish and administer their own educational institutions, that is mentioned in Article 30. every minority, whether it is linguistic or religious minority, have the right to establish and administer their own educational institutions. And the 10th and last category is that right to constitutional remedies mentioned in Article 32. Under this, Article 32 describes 5 writs that are habeas corpus, mandamus, prohibition, certiorari and quo warranto are the 5 writs which ensures that the fundamental rights are justiciable. If somebody is denied, they can regain that through a judicial procedure. And this Article 32, it is known as there is a speciality. The Article 32 is known as the soul and heart of the Indian Constitution. Then that is the heart of Constitution, and it pumps the blood into the different parts of, and that is the spirit of the Constitution, and then it is called as the soul and heart of the Constitution, right to constitutional remedies mentioned in the Article 32. That is the end of the chapter. Thank you for listening, and in the next video we will come again with another chapter on Indian polity.